Section 144 deals with orders for maintenance of wives, children, and parents. Bharatiya Nagarik Suraksha Sanhita, BNSS. 2023 by Advocate Sir Mayank Samkar, replacing Section 125 CUPS. BNSS 144 is a successor to Section 125 of the CUPS, aiming to streamline the process and improve efficiency in handling maintenance cases. The primary purpose of this section is to prevent destitution and ensure the basic needs of dependents are met when they are neglected or abandoned by their family members. The section applies to wives, children, and parents, and it emphasizes the responsibility of individuals to provide maintenance if they have the means to do so. Empowerment. It aims to empower women and dependents to seek support when they are financially unable to support themselves. A prevention of destitution. The provision aims to prevent starvation and vagrancy by ensuring that dependents receive adequate maintenance. A balancing rights. It recognizes the rights of both the claimant and the person obligated to provide maintenance, ensuring that the process is fair and just. Judicial interpretations. Case law and judicial interpretations play a crucial role in shaping the application and understanding of Section 144, ensuring that it is implemented effectively and in accordance with its intent. Round Section 144. Order for maintenance of wives, children, and parents. 1. If any person having sufficient means neglects or refuses to maintain a. his wife, unable to maintain herself, or b. his legitimate or illegitimate child, whether married or not, unable to maintain itself, or c. his legitimate or illegitimate child, not being a married daughter, who has attained majority, where such child is, by reason of any physical or mental abnormality or injury, unable to maintain itself, or d. his father or mother, unable to maintain himself or herself. A magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at such monthly rate as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct, provided that the magistrate may order the father of a female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such female child, if married, is not possessed of sufficient means, provided further that the magistrate may, during the pendency of the proceeding regarding monthly allowance for the maintenance under this subsection, order such person to make a monthly allowance for the interim maintenance of his wife or such child, father or mother, and the expenses of such proceeding which the magistrate considers reasonable, and to pay the same to such person as the magistrate may from time to time direct, provided also that an application for the monthly allowance for the interim maintenance and expenses of proceeding under the second proviso shall, as far as possible, be disposed of within 60 days from the date of the service of notice of the application to such person. Explanation for the purposes of this chapter. Wife includes a woman who has been divorced by, or has obtained a divorce from, her husband and has not remarried. 2. Any such allowance for the maintenance or interim maintenance and expenses of proceeding shall be payable from the date of the order, or if so ordered, from the date of the application for maintenance or interim maintenance and expenses of proceeding, as the case may be. 3. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person, for the whole or any part of each month's allowance for the maintenance or the interim maintenance and expenses of proceeding, as the case may be, remaining unpaid after the execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made, provided that no warrant shall be issued for the recovery of any amount due under this section, unless application be made to the court to levy such amount within a period of 1 year from the date 1. which it became due, provided further that if such person offers to maintain his wife on condition of her living with him, and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her, and may make an order under this section notwithstanding such offer, if he is satisfied that there is just ground for so doing. Explanation: if a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for his wife's refusal to live with him. 4. No wife shall be entitled to receive an allowance for the maintenance or the interim maintenance and expenses of proceeding from her husband under this section if she is living in adultery, or if, without any sufficient reason, she refuses to live with her husband, or if they are living separately by mutual consent. 5. On proof that any wife in whose favor an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order. Important key knowledge: 1. Know your rights and responsibilities. Understanding your legal rights is the first step in resolving any family dispute. Whether you are seeking a divorce, maintenance, or child custody, knowing what the law says about your entitlements and obligations will empower you to make informed decisions. 2. Seek legal advice early. Consulting a family lawyer as soon as a dispute arises is crucial. A lawyer will guide you through the process, help prepare necessary documents, and represent your interests in court. Legal professionals can also advise you on the viability of alternative dispute resolution mechanisms like mediation. 3. Consider mediation. Mediation is a valuable tool for resolving family disputes amicably. It saves time, reduces the emotional toll of court proceedings, and can lead to mutually agreeable solutions. If mediation fails, litigation is the next step, but it should be considered only when necessary. 4. Prepare for court proceedings. If your case proceeds to court, it's important to be prepared with all necessary evidence and documentation. For divorce and maintenance cases, this includes financial statements, proof of expenses, and other relevant documents. In child custody cases, the court will focus on the child's welfare, so evidence related to the child's emotional and physical well-being is critical. Interim relief. If there is an urgent need for support or temporary custody arrangements, you can seek interim orders from the court. These orders provide immediate relief while your case is pending, ensuring that your financial and custodial needs are addressed without delay. 6. Appeals and higher courts. If the judgment in your case does not favor you, there is always the option to appeal to a higher court. However, the appeal process can be lengthy and costly, so it's important to evaluate whether it's in your best interest to pursue it. Judgment Shah Bano Begum v. Mohammed Ahmed Van, 1985, where the Supreme Court ruled in favor of a divorced Muslim woman's right to maintenance, and Rainish v. Nahay 2020, which emphasized that a wife's right to maintenance under Section 125 of the CUPS cannot be infringed by agreements. 2. Sarun Raini v. Sudarshan Kumar Chapa, 1984, Forsk 90. The Supreme Court dealt with the issue of maintenance under the Hindu Marriage Act. The court held that a wife is entitled to maintenance even if she is living separately from her husband, as long as the separation is not by mutual consent. The judgment emphasized that the husband's duty to maintain his wife does not end with the dissolution of their marital relationship, but extends as long as the wife is unable to support herself. 3. Rainish v. Nihay 2020, 7 Sec 120, dealt with the issue of the quantum of maintenance in divorce proceedings. The Supreme Court provided detailed guidelines on how to determine the amount of maintenance payable to the wife after divorce. The judgment emphasized the need for transparency and clarity in determining maintenance and introduced a formula for calculating the maintenance based on the husband's income and the wife's needs. The case was significant in establishing a more standardized approach to alimony and maintenance. Condition for maintenance: 1. Inability to maintain. The person claiming maintenance must be unable to support themselves financially. 2. Neglect or refusal. The person from whom maintenance is claimed must have sufficient means but have neglected or refused to provide financial support. 3. Sufficient means. This refers to a person's ability to support them, which includes income from employment, business, property, or other assets. 4. Who can claim. Wives, children, including those who have attained majority but are unable to maintain themselves, and parents. 5. Interim maintenance. During the pendency of the maintenance proceedings, the court can order interim maintenance to ensure the claimant has temporary support. 6. Divorced wives. A divorced wife can claim maintenance as well, provided she has not remarried. 7. Female child. In the case of a female child, the father may be ordered to provide maintenance until she attains majority, especially if the husband does not have sufficient means. Wait. Proof of neglect or refusal. The court must be satisfied that the person responsible for maintenance has willfully neglected or refused to provide financial support despite having sufficient means. Procedure for maintenance. To claim maintenance under Section 144 of the Bharatiya Nagarik Suraksha Sanhita, BNSS, the claimant, wife, child, or parent, must file an application with the judicial magistrate, a first class or metropolitan magistrate, stating the reasons for seeking maintenance and the relationship with the respondent. The application should also include proof of the respondent's neglect or refusal to provide financial support. The court will then issue a notice to the respondent, who must appear in court and respond to the claim. Both parties will have an opportunity to present evidence, and the court will consider the evidence and arguments before issuing an order regarding the maintenance amount and payment conditions. A maintenance order. The court will issue an order specifying the amount of maintenance to be paid and the frequency of the payment, monthly or otherwise. The court may also specify the method of payment, bank transfer, direct deposit, etc. Conclusion. Section 144 of the Bharatiya Nagarik Suraksha Sanhita, BNSS, ensures that individuals, including spouses, children, and parents, who are unable to support themselves financially, can receive maintenance from those with sufficient resources. This provision aims to protect vulnerable family members and prevent them from becoming destitute after a breakdown in their relationships.